Good afternoon, Mr. Chair.
Since you are
members.
first in our list of, you have the floor.
Thank you. Ed Howard, Senior Counsel with the Center for Public Interest Law at the University of San Diego School of Law. For 30-plus years, the center has been the nation's flagship institution studying licensing agencies such as the CSLB. Our staff have been appointed as enforcement monitors for the Contractor State Licensing Board, the Medical Board, the Athletic Commission, the State Bar, and has been involved generally in overseeing, from a consumer's point of view, licensing agencies for that period of time. Mr. Chairman and Senator, I do want to highlight one thing right off the bat, and that is that already Senators Hill and Hancock, what we've just heard from the Contractor State Licensing Board is that your leadership on this issue has already paid off in a significant way. When we hear that the Contractor State Licensing Board has begun being proactive in looking at court files to try and prevent the tragedy in Berkeley from ever happening again, that is, with respect, attributable, I think, to your leadership, Senators, and consumers throughout the state should be grateful to you. I'd like to talk briefly about three things. The first is to do a quick overview of licensure and its relationship to the issues especially related to settlement. The second is I want to touch briefly upon enforcement, what it is and what it isn't. And third, I would like to talk a little bit specifically about settlements and specifically some of the objections that we've heard to them. First, as it relates to licensure, licensure is a very dramatic interference of government into the private market. It results uniformly in higher prices for consumers and less consumer choice. It correspondingly is a huge benefit to licensees. Both senators and Senator Wachowski have been in the building a while. It is rare, if not unheard of, to ever hear of a trade association representing a licensed profession to come before this legislature and ask not to be licensed. And the reason is because licensure, while it also affords consumers enormous protection, also affords regulated entities enormous benefits in a marketplace. They are essentially a legal monopoly. And so when I think it is fair to benchmark objections or claims to regulation from a regulated industry against the fact that that same industry is enjoying a terrific advantage when it comes to being licensed. The second related point about licensure is that it is not about making individual consumers whole for damages they may have suffered. It's not about that. That's what the civil tort system is for. Licensure is about harm prevention prospectively. Licensure looks at past bad acts and, just like an insurance company, tries to forecast whether or not those past bad acts mean that somebody has fallen below a legal standard of care such that we ought to take away or restrain their ability to practice this trade. So licensure is about looking in the past, about preventing harm in the future. And when it comes to that core task, DCA boards and bureaus are inherently reactive. We don't send state employees out to do random inspections, by and large. There's a few exceptions to that. But by and large, to do random exceptions on a wholesale scale. Rather, we are entirely dependent when it comes to protecting consumers to what comes in. That's a critical point here. Department of Consumer Affairs licensing boards and bureaus, by and large, and especially this one, are basically dependent upon what comes into them in order to figure out whether or not they need to take action against a particular licensee. Now, notably, anybody can submit a complaint, whether it's to the medical board or the Contractor State Licensing Board. There is no prior process of vetting it. It can be sent in by someone who's incredibly credible and powerful, and it can be sent in by an individual homeowner who's just suffered at the hands of an individual contractor. Yet each complaint is vetted by the professionals in each Department of Consumer Affairs licensing agency. And in fact, one way to look at these licensing agencies is they are complaint evaluation machines. That's hugely what they know how to do. They know how to exercise their judgment to choose between potentially important and good cases and those that aren't. And it is simply logically true that the more information that a board gets in, the better able it is to calibrate where to put its resources on the basis of where the potential problem licensees are. So this board does not get enough information. As the enforcement monitor said, quote, "The flow of information into CSLB about licensee misconduct is generally inadequate. CSLB lacks mandatory reporting statutes applicable to other state agencies." This board does not get all of the kinds of information that other boards routinely get, and that needs to be fixed. So I next want to talk a tiny little bit about what settlements. Settlement is not a verdict or a judgment. A settlement commonly does not admit liability. A settlement very commonly will not even recite necessarily the allegations that were in the underlying complaint. But what a settlement is exactly what you heard the enforcement chief of the CSLB say it is. It is simply a lead. It's simply a beginning point of an inquiry. And we've heard in the past that when these settlements come into all of the other boards, all of the many boards that have such a reporting requirement, they're treated and given no additional dignity than a general complaint from a consumer. It's just one more possible lead to look into. Now, can the CSLB be trusted to be careful in picking and choosing between cases that are good ones and cases that are bad ones? Well, the data tells one story. In 2014, there were about 18,000 complaints that went into this board. That led to a mere 472 cases opened by the Attorney General. In 2005, this board began fingerprinting licensees to see whether or not they had been convicted of felony convictions. And in 2013 through 14, they received 8,000 arrest reports that resulted in only 249 legal actions. So this board, like all of the other DCA boards, does not simply take a piece of paper, whether it's a settlement or a complaint, and rush to court to file anything. They are careful, meticulous, miserly, and small c conservative with the kinds of cases they bring and how many they bring. And part of the reason for that is when it comes to ultimate discipline, these boards have the second hardest burden of proof in the law. The hardest is the reasonable doubt standard for a criminal case. But the second hardest is clear and convincing evidence. So not only are they careful and meticulous because it makes sense to do that in order to protect consumers and not punish licensees who shouldn't be punished, they also have to do it because they're mindful that at the end of the day, they have to make this enormous burden of proof. They have to meet the clear and convincing evidence standard. Okay, so finally, I want to talk a little bit about some of the objections we've heard to settlement disclosure from industry. One of them, in listening to industry, I have personally found quite persuasive. The second, I would say the two other arguments I have found unpersuasive. And I want to talk about the persuasive one first. I think that in the discussions that I've heard from industry, including my colleague here on the panel most eloquently, I think that industry has made a persuasive case that this industry has different facets about it than some of the other industries that are subject to reporting. And therefore, I think it makes sense for the board, as we heard here today, to make the study of the issue that the board has said they want to make the study of and come back with feedback about what kinds of settlements, postured in which way are the best use of the board's time. I think that's a very useful thing for the legislature to hear about when it comes to settlement reporting. I don't think that industry has made a persuasive case on three other points. The first is the underlying question of whether or not settlements should ever be reported under any circumstance to this board. One argument that we've heard is that essentially all lawsuits in this area are frivolous. That, and hence all settlements, likewise frivolous. That can't be logically. Either that means that all of the actors in this sector, large and small, are excellent actors, perfect, never make a mistake that would warrant a lawsuit, or it means very counterintuitively that poor quality licensees who hurt people get sued as much and settle in the same amounts as contractors that never do. That fundamentally misapprehends how the plaintiff's bar works. And neither of those two things, I think, are persuasive arguments that say that the board shouldn't even look at any form of settlement reporting. The second argument we've heard, I think, is frankly more of a rhetorical one, and that is that had there been a requirement of settlement reporting prior to the tragedy in Berkeley, it wouldn't have prevented it. Well, of course, that's obviously true, but it's not respectfully the point. We never know with any degree of precision whether or not a settlement at any particular time will graduate into an enforcement action that might have prevented this tragedy in the first place. Instead, what we do know from the Berkeley tragedy is that this board lacks a tool that other boards have, and as you heard from your first panel, find useful in protecting consumers. The third argument I've heard is a fear that settlement reporting will lead to unfair disciplinary actions against licensees. But respectfully, that foundationally misapprehends the way that licensure works. These boards are able to distinguish and understand what a settlement is and what it isn't. And as we just heard the head of enforcement talk, I think, very sensitively and knowledgeably about the role that the investigations they're taking now because of your leadership, senators, underscores the fact that we can trust these boards to not act in a way that is mechanical and unthinking with this information. So, in conclusion, and thank you for your patience, senators, just because there are some things about this task that may be challenging, it's no reason not to do the easy things. The easy things are requiring cross-reporting between other state agencies such as Cal OSHA and the Division of Occupational Health and Safety, which, for example, I think last year fined $165,000 to 2 licensed contractors whose negligence contributed to the collapse of a part of the 101 freeway, seriously injuring 3 workers. Our government agencies should be talking to each other and cross-reporting each other. That's an easy one. Likewise, a lot of the objections that we've heard to settlement disclosures don't apply to individual contractors or contractors that are not a part of extremely large projects. An individual contractor redoing my bathroom or whatnot, individual settlement reporting is applied to those, doesn't have a lot of the complications that industry has said when it talks about larger projects. Finally, just because something is hard doesn't mean you give up on it. And I think that this is such an important tool, literally a matter of life and death, that it makes sense to try and calibrate, again, listening to the Contractor State Licensing Board, try to calibrate exactly how to do this reporting in a way that makes sense. There is one place where regulators, consumers, and industry all agree. Not a single one of the 3 stakeholder groups involved in DCA licensure wants regulators to look at documents that don't make any sense for them to look at. Consumers aren't benefited by that, licensees are harmed by that, and the regulator is wasting its time. The person and entity best situated to tell us what's useful and what's not is the board itself. And we welcome the board's promise of a detailed analysis of that question. And with that, thank you again for your leadership. And
thank you, Mr. Howard. Appreciate it. Ms. Murray, welcome. Good afternoon.
Thank you very much, and thanks to the committee for convening this oversight hearing. I'm Marjorie Murray from the Center for California Homeowner Association Law. We advocate for homeowners living in the state's 50,000 common interest developments, otherwise known as homeowner associations. We have been cataloging the construction defect issue for more than a decade. Catalog means documenting, and that means in those instances where we can get a hold of them, we obtain the complaints and we also obtain the settlement documents. And those are, as Mr. Vogt says, those documents are not particularly easy to get your hands on because they are usually written with a confidentiality agreement or confidentiality clause, preventing boards and even homeowners from releasing them. I want to address the consumer impacts of construction defects and construction defect litigation and the huge impacts it has on buyers, on local governments, and also on nonprofit developers of association housing, of affordable housing in general. And I think one of the points I'd like to make here is that construction defects and all the ramifications of it, we're talking about an affordability issue. Because usually what happens in the instance of litigation filed by a homeowner association is that a settlement may be reached, but the way the settlement monies are parsed out, the law firm takes 2/3 of it, and then the homeowners are left holding the repair bag. So the cost of repairs is borne through loans, special assessments, increases in regular assessments in order to actually accomplish the repairs because the settlement dollars don't cover the cost of repairs. So my remarks today really have to do with the financial impacts of construction defects, construction defect litigation, and the settlements. And we would really welcome having the board collect as many settlements as it can get its hands on to evaluate not only the track record of specific developers, which of course I think we all acknowledge is not necessarily an acknowledgement or admission or an indication of wrongdoing, but rather, as Mr. Vogt says, provide leads that will cause the board to do a closer examination of a particular developer or contractor. Information about developers and contractors who provide substandard housing is vital information for buyers who are thinking of buying into an association home. It's also vital for boards who have to make decisions about repairs, capital repairs to the association plant, and also to local governments and nonprofit developers. I'd like to, at this point, give you an example of how this works. The City and County of San Francisco, through its redevelopment agency, permitted a developer to build 188 units of below market rate condos. Completed in 2008, half the homes were sold to monolingual Chinese families. Buyers complained from the initial move-in about construction defects, windows, roofs, HVAC systems that didn't work. In 2010, the homeowners sued the developer and got a $1.8 million settlement. The money came from the developer's insurance, but the proceeds were insufficient for repairs since the law firm took 2/3 of the settlement money. Homeowners are now being required to finance the repairs via increased assessments. Said one homeowner, "My assessments will soon outstrip my mortgage." This well-known developer, it turns out, had been sued by homeowners in other affordable housing subdivisions in Oakland and has defaulted on $26 million in loans arranged through the city of Pittsburgh for a redevelopment project. So I just want to emphasize that construction defects and litigation is an enormous issue for common interest developments, which are the fastest growing form of housing in the state. We have documented these case studies over and over again with the unsuspecting consumer buying a home in a common interest development only to discover after moving in it is riddled with construction defects and that the buyer is ultimately going to be saddled with the cost of repairs because the settlement proceeds are insufficient. And I welcome any questions from the committee.
Very good. Thank you, Ms. Murray. Mr. Camarota, welcome. Good afternoon. And we will have questions after that we'll be able to ask. Thank you.
Thank you, Senator, and all of you for inviting me to participate in this hearing. I guess I want to begin with a few things about what we're talking about right now, not only construction defects, but a lot of the discussion from the previous panel with the various enforcement agencies and local agencies. I think there were a lot of promising ideas that were put forth there. So I just simply want to say that to the extent that my comments are a bit negative, they're really designed towards the use of settlements and not here to say that there aren't other things that can be done or should be done in the context of what the purpose of your bill is or the purpose of the legislature or even CSLB. Let me begin by pointing out that construction defect litigation is different, and it is different in a very stark way from the types of tort actions and in types of licensing agencies and professions that are subject to those licensing agencies, particularly since 2002. And the reason for that is in 2002, this legislature changed fundamentally construction defect law. What they did was to repeal the Oss versus Superior Court decision, which is a California Supreme Court decision. And since we do have some lawyers in the room, I just want to point out that you know that it's an essential element of all tort law that you have to prove that you've been damaged, the plaintiff has been damaged in order to bring the case. In 2002, the legislature did away with the damage component in construction defect claims. They also did away with the fault standard. No longer will we have intentional misconduct or negligence or even strict liability. We have a statutory liability. That is a very significant difference from all the other professions that are licensed in California. If you go to a doctor and unfortunately they do something wrong, they replace the wrong hip, they sew the instruments of surgery back in the abdomen of the patient, whatever it is, that patient, that plaintiff is painfully aware that they've been damaged. There's no question about that. What happens, this is now, for the most part, high percentage of construction defect cases. The homeowner themselves has no idea that their home is involved in litigation. You live in the house, you own the house. Your house is in litigation. You have no idea that this is going on. How do we find that out? We get served with a complaint, and our first action is to contact the homeowner. They're our customer. We see that you've been living in this house for 9 years since you bought it. That's typically about the time lawsuits arise because the statute of limitations is 10 years. And we say, we have no contact from you. We have no records in our customer care department. Our warranty department has never been contacted by you. What's wrong with your house? They're surprised to learn that there's a concern with the house. If we're lucky enough to schedule an inspection and get their agreement to do an inspection in the house, we arrive at the house and we find the homeowner entirely uncooperative. What do I mean by that? The door is opened. They will not respond to questions. We ask them, show us what's wrong with your house, or at least point us to the room that it's in. We have to engage in a fishing expedition. Now, we've brought video cameras to these events because you would find it so unbelievable that people would do this kind of thing, but it happens, and it happens for the most part. You next move on to the discovery phase with the typical depositions. You've heard, some of you have heard me before talk about this, about the 40 or 50 different parties that are involved in these cases. Everyone from the guy who installed the community mailbox at the entrance to the subdivision to the poor guy who just delivered the lumber to the site. They're all involved, and each one of them has a lawyer, and they're all paying their lawyers at whatever the hourly rate is, and there's going to be depositions for weeks on end. Now we haven't begun to look at the latent defects. We've only looked at those defects that are revealed upon a visual inspection. What is the law when it comes to latent defects? The law is that the contractors pay for the destructive testing. That is, the taking apart of the house and the reconstruction of the house. That's the law, regardless of whether or not that destructive testing reveals that there is anything wrong with the house. That puts an enormous pressure on the defendants, the contractors, to say, instead of opening up that wall cavity, we're just going to wind up settling. The rule of thumb in the construction industry is that for every dollar we pay to the plaintiff, we spend $4 to $23 defending the action, proving that there's nothing wrong with the house. The law doesn't require damage. It doesn't require evidence of damage. It doesn't require fault. Everything gets alleged in these complaints. I welcome you to look at the complaints. They're very similar. They're produced on a word processor. They usually have 30-plus items in the house that could potentially be wrong with the house. Everything that could possibly be in a house is listed from A to triple Z as an element that's defective, including wood siding in a subdivision in which all the houses are just stucco. These are things that don't even exist in the entire subdivision. What's in a settlement? You have the defendant's name, you have the plaintiff's name, you have the amount of money. You don't have an allocation of fault, you don't have any indication of damage. To the testimony that was just given, you don't give the amount of money that the plaintiff's expert gets. We don't know how much that is. We don't know how much the plaintiff's attorney gets. We don't even know how much of that the homeowner gets. We don't know what's done with that money, whether the homeowner repairs the problem or goes to buy a new boat or a jet ski. Why do I say this? Because if it's a legitimate concern, I think every one of us who owns their own home would repair it. So it's important to know what it is that's being done with this money. Given the system, what I'm about to tell you shouldn't be surprising, but I'm pretty sure it will be. Our members report that 90+% of all new homes built in the state of California every year are subject to construction defect lawsuits within the statute of limitations period. That's a 10-year period. What does that mean? That settlements are entered into for those lawsuits for between 50 and 120,000 homes on an average year. Now, if you want to use this as a lead, I think that's going to bury CSLB. I don't see how on a statewide basis they can reasonably investigate that, and certainly not with the staff that they have now. If they have 18,000 complaints, as we heard, in an average year, last year, this is going to be orders of magnitude greater than that. I think at this point, in the interest of time, I will just simply pause and ask for questions.
Thank you, Mr. Cameron. Mr. Voigt, would you come up here, please, again, if you would be kind enough to? Thank you. And not being an attorney, the one problem that I have is asking a question and not knowing the answer. So I will ask you the question anyway, because I think it would be helpful. You heard the testimony and the issue related, which seems to be focused on subdivisions, multi-housing projects that are constructed, which I can certainly understand the problem and the challenge. Of the kind of research you've done recently, or I guess to say, of the complaints that you receive, of the lawsuits that you've witnessed or looked at in the time frame, is that a large percent of those, or are we talking about a small percent of the overall number of possible settlements that you could see and identify and work from to notice and, here again, identify problems that may be created from those? I guess I've been thinking more of not necessarily the large subdivision, major builders in California, which is, I guess there are numbers of them, but most of your contractors are smaller in size and I'm sure in scope. So if you could help me with that, try to understand if he's related to a major concern and problem, or is that a small portion of the workload that you have?
Well, that's why we would want to work with our industry partners to develop criteria so that we're focused on those significant code violations that could result in life safety issues. It is true that there are a lot of lawsuits that are filed and settled which wouldn't warrant our investigation or use of our resources. As far as
Would you be able to identify those early on when you see them? And I mean, just as the ones that Mr. Camarota was talking about, that
yes, where when we mentioned 19,000 investigations, the majority of those are in the residential marketplace. And we work very closely with the Building Industry Association and others in resolving those disputes without taking a legal action. So we have a process in place that appears to be working very well. Where there could be a weakness that we may want to look at is in the commercial arena, in the larger projects. But I do want to emphasize that we would be focusing our resources on significant issues where you have code violations that would jeopardize life safety, and not a new development where you have complaints that are more minor in nature and not likely to result in somebody being seriously injured or even killed.
these are complaints that you would find from local building officials, or where they're reactive rather than the proactive approach, whereby looking at settlements and determining that information from those. Are you seeing a similar path by looking at settlements and being able to determine that information?
Well, I think it was well said that the settlement itself may not give you the information you need. You need to look at the lawsuit that was filed. It would just be a lead. And it's very true that if we were to look into every settlement that exists or every lawsuit, we just lack the resources to do that. So we will have to be judicial and identifying what our criteria would be.
Mr. Camarota, I'm trying to see the number of the dollar. Was it $50,000 to $100,000?
To 120,000.
50 to 120.
It's not a dollar amount. It's the number of homes on an average year that they would be receiving settlements for.
So that, would you agree that that would present a problem if those settlements, that, as he indicated, were identified in the manner in which they were presented?
Well, we're envisioning is setting up criteria. And so we do want to develop some criteria. We don't have to look at every settlement.
Right.
Otherwise, it could be overwhelming. When we did our study, we found that in some counties, up to 50% of the lawsuits that have been filed appeared to be somewhat construction related, have a contractor involved. We didn't look into it further. So we would have to be careful in looking at what we would look at.
Okay, thank you. Oh,
Well,
Senator Hancock.
some of the architects that I've talked to also raised the issue that contractors aren't required to have any continuing education. And I wondered if you think anything like that would be useful. I mean, what I'd be interested in here is focusing on the code violations that really do affect health and safety, noticing if a company has $26 million in 4 or 5 settlements over a period of time, that might be a clue as to something, unless every company has that. I'm assuming they don't, or do they, Mr. Camarota?
Yeah, unfortunately, you see what happens is the builder or the general contractor is the one whose name appears on the settlement. And if you have 100 houses or 1,000 houses in litigation, and we have that, I've seen them as high as 10,000 homes. I can tell you that with most of our large builders, they're paying more than the $26.5 million every year in settlements. And they may work out to be a relatively minor amount per home, but that won't surprise me a bit. In fact, I'm pretty certain that that's the case.
Okay, I just wondered if you would agree with that and if Mr. Howard would agree with that. Because we're trying to get to something that is a sensible approach to figure out who